This is Greg Frank. Can anybody at the county hear me? This is Greg Frank. Can anybody hear me?
Good evening, Frank. We can hear you.
Okay, thank you. It's just kind of doing some weird things at this end, so it sent me to a page I've never seen before.
Okay, Frank, we're having some technical difficulties. We'll go ahead and start the hearing, even though we can't see you on the screen inside the Barnes and Sawyer room.
Okay, I can see. Are you Mr. Miller?
I am.
All right, there. Mr. Miller and I have not met before, so I just wanted to make sure I knew who I was looking at. Now you know who you're looking at as well. Are we ready to go?
We are ready, Greg.
Okay, thank you. We'll go on the record now. The time is 6 p.m. on November 12th, 2024. This is a hearing for Deschutes County file numbers 247-2400-404-PA and 247-24-00-405-ZC. My name is Greg Frank, and I am the hearings officer in this matter, at least I hope. And before we turn to the particulars of the hearing, I will turn things over to Mr. Miller, who I was just found out who he was, and he'll describe how the electronic process works for this hearing. Go ahead, Mr. Miller.
Thank you, Hearings Officer Frank. Good evening. For the record, my name is Nathaniel Miller, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a comprehensive plan amendment to change the designation of the property from agricultural and surface mining to rural residential exception area, and a corresponding zone change to rezone the property from the exclusive farm use zone and surface mining to rural residential. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. The county has established time limits for testimony as follows. The applicant will have 30 minutes. Public agencies will have 10 minutes. The general public will have 3 minutes, and the applicant will have a rebuttal time of 10 minutes. The hearings officer can modify or eliminate these time limits. The testimony of the portion of the hearing will be concluded as follows. The applicant will present first, followed by agencies. Next, persons in support will testify. Then those in opposition will testify. And anyone neutral to the applicant's request will testify last. Afterward, the applicant will then be afforded an opportunity to present rebuttal testimony. And finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if wishing to testify, please add your name to the sign-in sheet. I will use this list to call participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device. Or if you called in, dial *9. In addition to oral testimony, if anyone has any written testimony to submit, please hand it to me directly. If you are in person, please submit your written testimony to me after your testimony. If you are participating remotely, you can submit your written testimony to me via email at nathaniel.miller@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. At this time, I would like to ask if there are any objections to the format of the hearing. If you are attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing back over to Hearings Officer Frank.
Thank you, Mr. Miller. As Mr. Miller described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. I'd ask for your patience as we make sure we get through each of the steps that Mr. Miller just outlined. This application is being considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They were also set forth in the staff report. The public notice and the staff report are posted on the county website, and they are also available directly from staff upon request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why that criterion must apply, and to do so with such specificity so that the other participants in the hearing may respond, and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes, in other words, stops, your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes any action for damages in circuit court. As I just noted, I serve as a county hearings officer and have been assigned in this matter. In that role, it's my job to be a neutral decision maker. Thus, while I may have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant. And although I will make a note that in times past, I have been a hearings officer for the city of Bend. For anybody thinks that I may be prejudiced towards Bend, I will just note that the city of Bend and I didn't see eye to eye in a number of cases, but I also agreed with the city of Bend in a number of cases. I make my decisions based on the facts. I make my decisions based on the relevant law. But other than that disclosure that I have had prior employment or contractual employment with the city of Bend, I'm not aware of anything that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I have not had any ex parte contacts with anyone in this case to disclose. It is my obligation to preside over this hearing in an efficient manner. Before we go any further, I would ask, and Mr. Miller, you can help me on this one. Before we go any further, does anyone who is present, either in person or remotely, wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? Mr. Miller, if you'll let me know if there's any objections, and I'll have a discussion with those folks.
There are no objections in the room. Hearings Officer Frank.
Thank you. Then hearing none, I will turn it back to Mr. Miller to deliver the staff report. Before I do that, Mr. Miller, I just want as a kind of a follow-up to my last comment. Mr. Miller did send me a copy of correspondence from Central Oregon Land Watch, which is dated today. I was out of my office until about 4:30, so I picked it up about 4:30. I just want to disclose that I have reviewed on a cursory basis pages 1 through and including 20, which is basically the letter from Central Oregon Land Watch. I just wanted you to know I have looked at that. Have I made any decisions based on that? No. Have I fully understood all the points that have been raised in that letter? No. That's what this hearing's for, is to provide me with additional details in this case. I would also disclose that I have reviewed the staff report pretty carefully in this case as well. Mr. Miller, sorry, I didn't mean to interrupt you.
Thank you, Hearings Officer Frank. We'll go ahead and continue with the staff report at this time. The subject property is located at 60725 Arnold Market Road and is approximately 279 acres in size. The property is southeast of the city of Bend, just south of Rickard Road. The urban growth boundary for the city of Bend is to the northwest on the west side of 27th Street. As noted earlier, the applicant requests an approval of a comprehensive plan amendment to change the designation from agricultural and surface mining to rural residential exception area. The applicant also requests a corresponding zone change to rezone the subject property from exclusive farm use and surface mining to rural residential. No Goal 3 exception is proposed. The applicant has provided evidence in the record that the property does not contain farmable soil and is incorrectly designated as agricultural land. In addition to the burden of proof, the applicant has submitted a soil study from Red Hill Soils and a traffic study by Transite Consulting LLC in support of the proposal. During the review, staff received 3 comments to the record in opposition to the proposal. One letter of opposition expressed concerns with increased residential density in the area. The other comments raised concern about increased traffic volumes and the loss of farmland. Staff notes that a number of nearby residents did inquire about the proposal after receiving notice. Staff responded to questions regarding the nature and scope of the application. After these initial contacts, no further comment for the record were received. Staff notes that since the issuance of the staff report on October 29th, one general inquiry was received. And also a letter of opposition was received from Central Oregon Land Watch this afternoon. All inquiries and comments are uploaded to the electronic record on the proposal webpage. This concludes the summary of the proposal. Staff is available for questions.
Thank you, Mr. Miller. I'm going to pose a question that I would ask that you, if you feel inclined to respond to either now or during your final comment period. And I honestly am not sure of the date of this document, but it's from Tia Lewis to you. And it included an applicant's response with respect to DLCD versus Clackamas County, which is a Court of Appeals, I believe, a Court of Appeals decision. And in essence, the way I read Ms. Lewis's comments was that the case was not applicable because it's not already zoned rural residential. But certainly, if you have any comments on that, I'd welcome those either now or at the end of the hearing, or if there's an open record period during the open record period. So that's my only comment or question. Any response at this time, or should I go straight into applicant's testimony?
Staff understands the email from Tia Lewis to be additional materials that she wanted to be included in the record for consideration. So I think staff's understanding is that they were directed more towards you in the hearings that were scheduled to take place for this application.
Okay, no problem. The final thing I have before, and the applicant should be prepared if the applicant is present either remotely or on in person. The time limits that were discussed by Mr. Miller are acceptable to me. If in fact someone wishes to exceed their time limit, please at the start of your testimony, let me know the reason that is necessary, at least from your perspective, and I'll make a decision on that. So this will be the time and the place for the applicant. If there are going to be testimony, first and last name and mailing address, please.
Good evening. Thank you. I'm
Hey.
Tia Lewis. I'm an attorney for the applicant, and with me is Sarah Ainselman, will also speak briefly after my presentation.
Go
She's
ahead,
with
ma'am. Address, please.
360 North or Southwest Bond Street, Suite 500, Bend, Oregon, 97702.
Oh, I would hope that's not the hardest question I asked tonight.
My work address, I don't recite it very often, so it was kind of hard.
Go ahead, ma'am.
Okay, and then how do I advance this? Is it the left and right? Okay, thank you so much. Okay, so thank you for, I'm going to be brief because our application materials are pretty extensive, and I'll try to answer also the question you asked at the end of my presentation. But as staff indicated, the property is 279 acres. It currently has 105 acres of surface mine zoning. It was surface mine site 392. And this site, the EC is in the record as Exhibit 9. This site was protected for fill material. The county did not determine that the aggregate resource on the site was significant, but they did protect it for fill material. I'm going to advance this just so that you can see the surrounding area. So the subject property is outlined in red on this screen, and you can see an outline of black. That is the Knott landfill. Subject property is right across Rickard Road from the Knott landfill. What you see in blue is the Bend UGB. The subject property is less than a half a mile from the UGB. And the rounder part of that blue UGB is what's called CAP. That's an area that has yet to be annexed into the city of Bend. It's in the process of being planned. It was brought inside the UGB on the last UGB expansion, and it has approximately 479 acres there with about 1,200 dwelling units planned, an elementary school and some commercial land less than a mile from this property. And it's going to be annexed and brought into the city in the next few months. The adjacent to the southeast of the subject parcel, you can see an irrigation pivot that is owned by the Parks and Rec District, and that irrigation pivot is being utilized to protect the irrigation rights for use eventually in the park. The land is being given to the farmer to irrigate for hay, and there is no profit or commercial enterprise being conducted as a part of the water. It's solely to protect the water rights. There are some water rights themselves on the subject property, but there is no irrigation infrastructure. And in fact, Arnold Irrigation District has indicated they will be piping the canal in this area, and they will be stubbing an irrigation pipe to the lower the acreage that has the pivot, but not to the subject property. The subject property is surrounded by non-resource uses as confirmed in the staff report on pages 4 and 5 and on pages 37 and 38. And there is no agricultural use adjacent to the subject property or in the immediate vicinity. As I indicated, the property was mined. It's known as the Rose Pit, and that was named after the owner, Mr. Bud Rose. Approximately 91 acres of the property was mined for fill material from 1993 through 2005. Mining ceased in 2005, and the reclamation incurred incrementally during the post-mining period. As a part of the mining, they incrementally reclaimed, and then they again incrementally reclaimed some of the land up until 2010, when Dogami confirmed that the reclamation required under Dogami's rules was complete and closed its file in 2011. There's the Dogami file closure and evidence of the completeness is in the record at Exhibit 10. The Park District bought the property in 2023 with the intent to develop and plan it for a regional park. In 2023, the Park District immediately applied for a modified reclamation plan with the county. And the reason for that was because so Dogami confirmed that its reclamation was complete, but the county had its own reclamation plan, and the factual data and information required to reclaim under the county plan was impossible. The amount of material that was estimated to be on site was grossly overestimated, and the reclamation plan could not be completed. And so in 2023, the Parks and Rec District applied for the modified reclamation plan, and that decision is in the record at, excuse me, sorry. Exhibit 4, as well as we had a Wallace Group conduct a surface mining reclamation evaluation, and that is in the record as Exhibit 8. What was determined as a part of that modified reclamation plan is that there were a number of items remaining to be done to reclaim the land, and then there was some the last remaining reclamation that remains to be done was revegetation. And the revegetation was approved to be completed contemporaneously with park development, so that the property was not revegetated and then torn up when the master plan was implemented. There was a prior attempt at rezoning this property in 2011, and that application was denied based on the lack of reclamation. That application was filed prior to the time that Dogami had closed its file, and it was also prior to the time that we have a modified reclamation plan that accurately represents the condition of the property and has verifiable and able to complete the actual reclamation requirements. So the evidence in the record establishes that the resource is fully mined, and it's time to rezone the property. That the surface mining zone is a transitional zone, and at the time that the resource is removed, it's time to rezone to another zone. So we have evidence to also establish that the property does not meet the definition of agricultural land, and so the Park District chose the RR10 as the best zoning category to develop the park in a master plan in conjunction with the adjacent property. I'm going to skip this one and come back to it. So these are the rezoning standards under the county's code. This is DCC 18.136.020. I'm not going to go through each one of these in great detail because the application is pretty extensive, but the first one, that the change conforms with the comprehensive plan and is consistent with the plan's introductory statement and goals. The evidence addressing that criterion is found on pages 10 through 21 of the burden of proof, and it's summarized on pages 11 through 14 of the staff report. Specifically, the applicant addressed the agricultural lands policies in section 2.2 of the comprehensive plan, the water resources policies in section 2.5 of the comprehensive plan, surface mining policies in section 2.10, and the rural growth policies found in chapter 3. Or criterion B, that the change and classification is consistent with the purpose and intent of the proposed zone. The purpose and intent of the RR10 zone is to provide rural land use and development consistent with the rural character and to allow public input for non-residential uses. The evidence and argument addressing this criterion is found on page 21 of the burden of proof and is summarized on page 14 of the staff report. And the park master plan process is a public process. The CUP is required for a park in the RR10 zone and a site plan which provides ample opportunity for public input for non-residential uses. For sub-criterion C, that the change in zoning will serve the health, safety, and welfare, considering the public services and facilities. The evidence addressing that criterion is found on pages 21 through 22 of the burden of proof and on pages 15 through 16 of the staff report. For sub 2, the evidence is found on pages 22 through 23 of the burden of proof and summarized on page 16 of the staff report. The evidence in the record establishes that the public facilities and services are adequate to serve the uses allowed in the RR10 zone and that the impacts of the surrounding use will be consistent with the goals and policies in the comprehensive plan. And lastly, under criterion D, that there's been a change in circumstances or a mistake. The evidence addressing that criterion is found on pages 23 through 25 of the burden of proof and summarized on pages 16 through 18 of the staff report. As far as a mistake, the county zoning was implemented in 1979, and it was based on very generalized soil info, not site-specific, and on a very high scale. We now have the benefit of a site-specific soil study establishing that these are not agricultural soils. With regard to a change in circumstances, there really isn't much that hasn't changed since this property was zoned in 1979. We currently, in addition to having the availability of accurate soils data, we also have a lack of viability of farm operations in the area and the surrounding development consisting exclusively of non-resource uses. So those are the county criteria. I'm going to talk a minute about the state law, and I don't have a slide for this, so I'm just going to talk for a moment. So we filed this application under the non-resource process instead of a goal exception because we have evidence demonstrating that the property does not meet the definition of agricultural land. This process is regulated through the Oregon state statutes, the Oregon administrative rules, and the statewide planning goals. These laws are addressed on pages 25 through 45 of the burden of proof and summarized on pages 29 through 49 of the staff report. The statewide planning goals that are implicated are Goal 5 and Goal 3. Prior to 2 o'clock this afternoon, I did not think that there was any debate that the resource had been exhausted and that the rezoning from surface mining should occur. However, I did briefly review the information prepared by Landwatch, and it appears that they are arguing that we do not meet the criteria to rezone the land from surface mining to anything else at this point because according to Landwatch, the reclamation is not complete. As indicated in 2023, when the Park District purchased the land, they applied for a modification of the reclamation obligations because the reclamation obligations as they existed we could not comply with them, could not be met. So the modification of reclamation obligations and the decision in the record was designed to allow the Park District to apply for the zone change and complete the remaining revegetation part of the reclamation contemporaneously, not contingent upon the park development. And this was done to protect the public dollars and prevent the Park District from engaging in extensive and expensive revegetation efforts only to rip those up as a part of master planning and developing the park. With regard to Goal 3, the definition of agricultural land as used in Goal 3 is defined at OAR 660.033.0020 as lands that are classified predominantly in a soil class of 1 through 6 in Central Oregon. As discussed in the burden of proof and in the non-resource case law, Goal 3 and the state statutes specifically allow for a more detailed soil study and do not require use of the NCRS mapping. The Order 1 soil study submitted as Exhibit 6 establishes conclusively that the soil classifications are 66% Class 7s and 8s, and that soil study has been reviewed and certified by DLCD. Aside from the soils class, there are other suitability factors that must be analyzed as a part of a non-resource zone change. Those include things like soil fertility, suitability for grazing, availability of water, climatic conditions, and a number of other factors. The suitability factors were addressed by the soil scientist in Exhibit 6, and his findings are summarized on pages 29 through 34 of the burden of proof statement, as well as pages 33 through 38 of the staff report. The soil scientist, as well as the facts in the record, established that not one of the characteristics for the suitability factors indicate that this land should be used for any agricultural purpose. The additional factors that must be addressed are what some call the locational test, recently elaborated on in the 710 case, or what they call the Eden case. That's found at Administrative Rule 660-033-00201AC. And that requires an analysis of the subject property in the context of adjacent and nearby agricultural lands. What's important about this is that it requires that there be adjacent or nearby agricultural lands engaged in agricultural use. The evidence in this case establishes, and staff confirms, that there are no adjacent or nearby agricultural lands engaged in farm use. We did analyze the suitability of the land for grazing under the suitability factors, but because there are no nearby or adjacent agricultural lands, we did not analyze that under the locational test. And finally, there's the farm unit rule. The farm unit rule is found at OAR 660-033-0020 sub 1B. The farm unit rule discusses lands that are intermingled with lands in a farm unit. And I want to point out that staff specifically noted that the subject property does contain soils and capability classes other than 7 and 8, and asked the hearings officer to specifically make findings regarding the farm unit rule. But what I want to point out is that you first have to have a farm unit in order to analyze intermingled soils. And in this case, we have no farm unit. There is no agricultural use engaged on subject property or the adjacent or nearby lands. The farm unit rule, the farm unit is defined in ORS 215.230 as contiguous and non-continuous tracts in common ownership used by a farm operator for farm use. There is testimony in the record from Bend Parks and Rec District that the only activity occurring on the adjacent property associated with that pivot is to protect the irrigation rights so that they can be utilized as a part of the master planning of the park, and that there is no farm use occurring on that site. Go back to the slide on the, okay. So the key facts in this case are that we have the soils report, Exhibit 6, as well as the Wallace Group Reclamation Evaluation at Exhibit 8 that confirms the site does not no longer contains a significant aggregate or soil resource, and that the subject property is not agricultural land. It's 66% Class 7 and 8 soils. The transportation analysis, Exhibit 12, confirms that the map amendment and zone change complies with the TPR and will not significantly affect any transportation facility. And the proposed plan designation and zoning serves the public interest by rezoning unproductive agricultural land and fully mined surface mining land consistent with the surrounding lands to be used to plan a master plan park. I did have, as I indicated, a brief opportunity to review the submission by Landwatch, but I would like to reserve an opportunity for rebuttal, assuming that there will be some opposing testimony. And I do have Sarah that would like to say a few words on behalf of the Park District. Thank you. I would also be able to answer the hearings officer's question about that, that case that I submitted, which I could do now, or I could wait until later.
Your
if the
choice.
hearing officer has
Your
other
choice.
questions.
No, no additional questions, your choice about the case.
Okay, I'll go ahead and just tell you really quickly why I submitted that, and then we can let Sarah testify, and then we can talk about it more on rebuttal if need be. So there are a number of non-resource zone change cases being submitted to the county at this time, and one of the planners had asked for additional argument or briefing on the Clackamas County case that had just recently come out. It was in one of the other cases, but since we were submitting it in one of the other cases, we decided to submit it in this case too, in case the county had any concerns about the implications of that case on the subject application. That case concerns the application of an administrative rule that governs exception lands. So, and it stands for the fact that when exception lands when you've taken an exception, that you can't just do anything with the exception lands. You can only do what you've taken the exception for. And if you're going to do something more than that, you need to take another exception. And that's what that case stands for. And it specifically relies upon an administrative rule regarding exception lands. And that's not what this is. So that's why we submitted that argument about that case. Thank you.
Thank you, ma'am. Identify yourself for the record, please.
I'm Sarah Anselmant. I am a park planner with Bend Park and Recreation District.
Would you spell your last name?
Anselment, Anselment.
And your address, please.
799 Southwest Columbia Street, Bend, Oregon, 97703.
Tell me what you'd like to tell me.
So I've got a little history about our purchase of this property. I worked a lot on the acquisition. As Tia said, we purchased it about a year and a half ago for future park needs, knowing that property of this size is hard to find, especially this close to the UGB. It's similar to Big Sky Park or Pine Nursery Park. When we bought those, they were both just outside the UGB, and Big Sky Park still is, but both are in pretty close proximity to Bend. And in fact, Pine Nursery now abuts it. We purchased this knowing we would need to rezone the surface mined portion, and knowing we'd need to go through a rezone process for at least that portion. We got curious about rezoning to a designation that would allow a little bit more flexibility. We have parks that are zoned EFU, so we are familiar with the limitations of that designation. The SM zoning boundary is also a little bit irregular, so we didn't want to rezone just that portion and end up with this sort of irregular shaped almost island within the larger park site. So we reviewed possible zoning designations. We looked at open space and conservation, multiple use agricultural, and rural residential. And the rural residential zone conditionally allows public parks, playgrounds, recreation, and community centers, while the other designations limit one use or another, or just aren't as clearly defined. So we settled on rural residential because the conditionally permitted uses are well defined, and it allows for the largest variety of park and rec uses. We don't have plans to develop the property right now, but we do envision it as sort of a combination between Riley Ranch and Pine Nursery, if you're familiar with those. The southern portion of the property is nicely treed with some topographical changes, so we see that as probably remaining undeveloped except for maybe trails. And then the previously mined portion at the north end of the site is already disturbed, so we would focus any developed amenities in that area. And as Tia said, we also own the property to the southeast, which is zoned EFU. It does allow some park and rec uses. So when we do develop the park, we would work within that designation to determine which uses should be located on which parcel. And all of our park parks and facilities are developed with community input. So the rural residential zone maximizes the uses that we could develop when the time comes based on community needs and the community's input.
Thank you. That concludes the applicant's presentation.
Thank you. I have no questions at this time, and as a matter of right, you're going to be able to come back up under rebuttal. So anything that you wish to say later, you'll have that opportunity. So is there anyone wishing to speak on behalf of public agencies?
Hearings Officer Frank, we do not see any agencies online wanting to participate. I also just want to let you quickly know that we have your visual up here in the room.
Oh, okay. Well, that's lucky you, I guess. Maybe, maybe not. All right. This would be the time for the general public. I tend to like to have folks in the general public in favor of the application to go first as a group, and then we'll have those in opposition, and then those that are neutral. But this would be a time for those in favor. In support. Think this is a good idea. I'm reading body language. I'm assuming someone's coming up.
Yes, we have someone wanting to testify. Thank you.
Cool. All right, thank you. Identify
My name
yourself.
is Deb Reynolds and I live on Back Alley, which is on the south end of the property. And our property is adjacent to that on that end.
Okay, two
I
things.
think most of us,
Can I
yes.
interrupt you for a sec? First, I'm a terrible speller. Could you spell your last name for me, please?
Deb Reynolds, Reynolds, and we are on Back Alley, which is the southern end of this property.
And
It's
the
it's
the
a
address?
dirt road parallel to Rickard Road. And so that's where our ranch is.
I
So we
think-
own 29
but
acres on
I
that
still
side.
need, I still need your address.
What's that?
Address.
your-
please.
You're
Address, oh yeah, 21325 Back Alley,
you.
sorry.
No problem.
I think most of us on Back Alley, when we heard rural residential and got that, we thought that the Parks and Rec were going to sell this as 10-acre lots. I mean, because we didn't see in any of the paperwork, I looked all around, that wasn't going to happen until I think I wrote to Nathaniel, and then I found out a little bit about it. And so most of us, I think, are in favor of a park being developed on that rather than a development. And so we're really appreciative of Parks and Rec buying this. One of the things that I just have a question about is because Back Alley is not serviced by the county, we're not sure what's going to happen to that road. It is a dirt road, and I guess we're just wondering about traffic, and most of us back up to the forest, Deschutes National Forest, back of our properties. Some of us do, and so just wondering what's going to happen with the public coming into that park. And then I also was wondering about the mule deer population. There was something that was happening with DNR, I think, with that as well. But I would say that we are in favor of a park being developed there, and especially on the south side of just having trails in there, because there is beautiful rock outcroppings and trees and stuff in that part of the property. And so it would be, I'm looking forward to seeing the master plan and what they have in store for that piece of property. Thank you.
I appreciate your testimony. I'm going to ask staff and or the applicant to respond to you with your questions regarding the roadway and mule deer population. Anyone else? Mr. Miller testifying in favor and support?
Hearings Officer Frank, no one wishes to testify in addition in support of the proposal.
Okay, this would be the time and place then for anyone who is in opposition, doesn't like this proposal. If you're in person, please make sure Mr. Miller sees you. If you're remote, please raise your hand. Hi.
Hello. Good evening, Hearings Officer Frank. My name is Robin Hayakawa. I'm testifying today on behalf of Central Oregon Land Watch, where I work as an associate staff attorney.
Cool. I haven't seen you before. Would you do me a favor though, just like everyone else, give your address?
Yes, our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. I want to thank you for hearing public testimony on this land use application.
No problem.
Landwatch opposes this application to redesignate and rezone the subject property from agricultural, EFU, and surface mining to rural residential exception area and rural residential zoning for several reasons. The first reason we oppose this rezoning is that it's unnecessary. As the applicant appears to know, the desired development of a public park is conditionally allowed on agricultural land and in agricultural zones. Other instances of the applicant developing agricultural land into a public park exist, as you just heard. For example, Big Sky Park and Luke Damon Sports Complex to the northeast of Bend is sited entirely on land zoned EFU. The development of Big Sky has not been significantly encumbered by its agricultural designation, as it now includes baseball, softball, lacrosse, and soccer fields, as well as a playground, bike park, trails, dog park, and BMX track. Landwatch urges the hearings officer to protect the county's limited supply of agricultural land and deny an unnecessary attempt to spot zone this property when it could be developed as a public park under its current land use designation. Our second concern is that this application asks the county to make a non-agricultural lands determination based on a private soils report that has revised the previously mined area of the property from Class 6 to Class 7 non-agricultural soils. This is a playbook that has been used by the owners of this property before, and just like previous attempts, this application must fail as well. Evidence in the record shows that even though the 2023 amended reclamation plan required that the mined and filled area be covered with Class 6 non-irrigated / Class 3 irrigated topsoil, the application continues to attempt to exclude the mined and filled area from agricultural land consideration because it's compacted and rocky. Landwatch objects to this attempt to have it both ways, where the surface mining area has been reclaimed to its previous agricultural condition, but at the same time, it must be downgraded to non-agricultural land. Finally, Landwatch notes that the subject property remains agricultural land pursuant to OAR 660-033-020 sub 1 sub B, because it is intermingled with lands containing high value agricultural soils and exists within the same farm unit as those lands. Sub 1 sub B is also known as the farm unit rule and was written to prevent property owners from dividing farmland into a series of smaller properties until those properties alone cannot meet the definition of agricultural land. A property is likely to be part of a farm unit if it is in common ownership with adjacent commercial farm operations. Here, the subject property has been and continues to be under common ownership with the adjacent property, tax lot 300, where there is currently a farmer growing and harvesting a hay crop. Additionally, evidence submitted to the record by Landwatch shows that the subject property does have a history of grazing in conjunction with tax lot 300. And moreover, these two properties used to share substantial amounts of acreage and water rights before they were rearranged via a lot line adjustment in 2016. As a result, the subject property is agricultural land because it is part of a farm unit with tax lot 300, and the farm unit rule was written to prevent exactly the sort of rezoning of agricultural land that is being attempted here. Once again, based on these arguments, Landwatch respectfully urges the denial of this application. Thank you.
Thank you. Don't go away. I just want to, for your other folks from Central Oregon Land Watch who are more familiar with me, and probably Ms. Lewis is aware as well, I tend to ask questions on occasion that make people feel uncomfortable. And that's certainly my focus here. Landwatch has raised the issue multiple times with respect to the more specific soil study as compared to the generalized soil classification system that was used back in, I think, 1979. And I just want to make sure, are you arguing that those earlier decisions that I've made, as well as the arguments that I believe have gone at least up to LUBA on one or two occasions, are you arguing that the specific soil study shouldn't be considered? For what reason?
I'm not saying that the specific soil study shouldn't be considered necessarily, nor do I know every decision you've made. So I'm certainly not contradicting every decision you've made. But I think our largest issue is that the soil study that it was submitted carved off the 68 acres of surface mined land and revised it in a mapping unit to Class 7 soils. The 2023 amended reclamation plan required that that area be covered by 6 to 12 inches of the original topsoil that was removed from that land, which should have been Class 6 irrigated or Class 3 non-irrigated. So I would say our struggle is that the applicant is saying that this land will be reclaimed in the future. However, it is simultaneously saying that based on a failure or incomplete reclamation of the property, that it's no longer agricultural land.
So from your perspective, then, what reclamation plan is operative for my making a decision in this case?
It would be the 2023 amended reclamation plan.
And in all honesty, I haven't read that. So I appreciate you identifying that, and I will certainly review that to make sure. And the other issue that I'm curious about is the farm unit. I'm now paging through
Right, yeah.
the letter, which I didn't get until late this afternoon. As I said, I wasn't even in my office until probably 4:30. Can you cite me to the page you're looking at, a farm unit argument?
I believe it's one of the last arguments I made. I didn't actually bring a copy of my written comments up with me.
Miss Lewis, you're sitting back there. Could you give him a copy of it?
Argument 9.
And I'm not trying to put you on, well, I actually am trying to put you on the spot. That's the whole purpose of me understanding exactly what's going on.
It's argument 9 on page 15. And you can put me on the spot. I don't mind.
No, well done, then. I'm impressed. All right, so 8, 9, got it. Okay. So I just want to make sure I know what to look at. If you've already produced your argument fully on that. So I'm making a note to take a look at page 15, argument 9 regarding farm unit. Go ahead, sir. Anything else you want to tell me since I've disrupted your entire testimony?
No, I'm finished with my testimony.
Okay.
Well, I suppose I have one thing to add.
All right.
I feel like there was a lot of claims that there was no farm use happening in the area when there appears to be undisputed testimony in the record that the adjacent property owned by BPRD is currently in farm use growing a hay crop.
Okay. And your definition of farm use?
It would be the same as what is provided for under Oregon law.
Okay. Is that sort of the profit is used for a profit purpose?
Correct. There's no evidence in the record showing that the hay is not being sold for profit and money.
Okay. All right. And you understand, since this is your first time, and I tend to, at least in front of me, is I tend to be rougher on new people, so that when they show up and again in front of me, they can anticipate it fully. But I am basically setting this up so that Miss Lewis is going to have an opportunity for rebuttal. And if there's a open record period requested by anyone, that additional argument can be made then. That's why I'm asking the questions. I want you to understand I'm not trying to pick on you personally. What I am trying to do, though, is that you have looked at this probably a few more hours than I have. Miss Lewis and the Ben Parks representative have looked at it a really long time. And Mr. Miller's looked at it a really long time. And I don't have that much time to become unequivocally and absolutely familiar with what's going on. And so my questions are not meant necessarily to have you answer them perfectly. My questions are meant to make sure that I can fill up the record with facts and good arguments so that I can make a logical decision based on those facts and argument. So thank you so much for your testimony.
Thank you.
Thank you. Anyone else in opposition?
Hearings Officer Frank, there are no other people in the room or online who wish to testify in opposition.
Okay. Ms. Lewis, if you want to come back up, please. And you can be accompanied if necessary or appropriate.
Thank you. I'll do a brief rebuttal because we are going to need some post-hearing briefing to address the materials that Landwatch submitted tonight.
Let me just stop you there. Are you requesting the record to be remaining open, an open record period?
Yes, sir.
Okay, I just making it formal. Okay,
Thank you.
go ahead.
So I want to address the point that Landwatch made about the application being unnecessary. First of all, necessity isn't really an approval criterion. However, I do recognize that one of the approval criterion is that the zone change be in the public interest. And so I want to talk about that and why we chose this. And I think Sarah made a good point, but I'm going to make it a little bit more, is that there are parks that are in the EFU zone, and there are limitations on what can happen in the EFU zone. The park district spent a lot of money on this property. The park district immediately applied for a modification to the reclamation plan in order to get a reclamation plan approved that could actually be implemented. The idea that we were supposed to place Class 6 soils back down on top of the mined area, and the amount of soils estimated to be available to do that was grossly mischaracterized in the original site plan and in the original reclamation obligations. So it really requires a reading together of the soils report submitted by Andy Gallagher, as well as the assessment that the Wallace Group did on the mining reclamation, because the Class 6 soils were never there. And the Wallace Group identified what was there and what was available, that what we could realistically accomplish as far as a reclamation of this site. And the amount of material pulled off of this site was grossly different than what they thought they were getting into when they first established the mining plan. And so that's what the Wallace Group spent many months evaluating and prepared that extensive report, and what the 2003 reclamation plan is based on. And that 2003 plan, again, was designed to be implemented contemporaneously with the park development in order to preserve the public dollars associated with developing this park. The other reason that this is in the public interest and that the RR10 zone is the preferable zone to put the surface mining land into is because, first, it doesn't meet the definition of agricultural land, but for the park purposes, they need a zone that allows the flexibility to be able to develop facilities that we may or may not know exist today. I mean, today there's pickleball that didn't exist 10 years ago, and there are types of parks and recreation uses that evolve over time. The agricultural zone is designed to protect agricultural land and agricultural uses, and anything that occurs in the agricultural zone is secondary really to an agricultural use. It's regulated by state law and primarily by agency, by administrative rules, which routinely change, not only in terms of their language, but in terms of how they're interpreted. The RR10 zone is a local zone, and our local legislative officials can help the park district regulate what goes in that zone. We have the park district with an enormous expenditure of public money has more certainty with the RR10 zone, and they did not move to change the existing EFU land that has the pivot because they can utilize that land under the EFU. It has a lot of, as the Ms. Reynolds testified, a lot of topography and a lot of really beautiful natural features that the park district plans to keep as a part of the amenities in the park. And the disturbed surface mining land is where some of the more intensive recreational uses and the service uses, parking lots and bathrooms and those sorts of things will go. So the RR10 zone was chosen specifically with the idea in mind that the approval process and the allowable uses are locally controlled and regulated, and the park district has the county as its partner to help it plan that local park in accordance with to meet the needs of our community. With regard to the farm unit, the applicant testified in the application materials that the pivot is there solely to protect the water rights and that the farmer is not being charged any money for water or for leasing. So there's no profit occurring as a part of this watering of the land and the growing of hay. If we can get the farmer to testify as well that he wouldn't be able to make a profit. He's told us he couldn't sell any hay if he had to pay for a lease or the water or any of the facilities that go into operating that pivot. Hang on one second. I find it sort of hard to understand that we have Landwatch suggesting that we should utilize public dollars to spend more money to develop a park in a way that the park district is trying to be a steward of this public money, and they're trying to develop and plan for this property in a way that provides for a community benefit. Obviously, the surface mining is complete and ended, and it needs to be changed out of surface mining zoning. To suggest that it should go into EFU zoning and that this property could be an agricultural resource would be an irresponsible use of public dollars to put any money towards farming this land and utilizing it for any agricultural purpose. So I don't see how this aligns with Landwatch's mission. I understand when they oppose these types of applications because they don't want rural residential use on the urban fringe. But when they oppose these types of applications, we have a responsibility as a community to develop lands on the urban fringe and to zone lands appropriately on the urban fringe in a way that allows for an orderly transition and that allows for a redevelopment or a development in a way that is rural in nature, but that protects the lands on the urban fringe. And so it's important to coordinate planning along the urban fringe, and the parks are an important part of what our community needs. We have a growing community. We need the lands inside our UGB to provide for residential uses and affordable housing. And the Park District can't buy 400 acres inside the UGB to develop as a park. So they buy lands on the urban fringe and utilize the planning process that exists in order to provide community stewardship for these lands. So we urge you to approve this. And I would like to talk about a open record period.
All right, let's do that first, then I'm gonna come back. Well, no, let me make my comment since I was kind of tough on the land watch attorney. Let me just say that I'm not familiar with unnecessary applications being an approval criteria. I just don't see that. My obligation is to take an application that's in front of me and approve it or not approve it based on the approval criteria. Equally, your argument that there's a shepherding or stewardship that I should consider with the finances of the Park District, and that's just good public policy is also not an approval policy directly. I understand the public interest. You could make a clever legal argument on that, but quite honestly, how the Park District spends money is not the subject of this particular decision. And in some respects, the flexibility issue is kind of on the margins, but it's probably legitimate from a public. Is it the best public interest? Is give flexibility? So I can see that sort of. But I just wanted you to be aware that the dollars and cents argument doesn't carry any more weight than does other. Before I let you go, the issues that probably bother me the most is, and I'd like you as well as Landwatch to clarify, is the adjacent pivot, circle pivot, and why that's not an adjacent farm use. And I think, as I indicated to Central Oregon Landwatch, I'm asking this question of you as much to alert him that it's an issue that I'd like flushed out so that I can make a good decision on this. So if you could do that. And now let's talk about the time frame for the open record period. Mr. Miller has suggested the 19th, 26th, and the 3rd as 7-day open record period for everyone. The 19th, 4 p.m., 7-day rebuttal period would be 4 p.m. on the 26th. Oh, wonderful. That's it. So I won't say anymore. Comments on that proposed schedule, since the applicant, I believe, has a little more sway in these dates, at least for being longer. If you wish longer, please tell me and why.
So I have a question before I can answer that.
Go ahead.
Yeah. So typically the second period, the rebuttal, is to address information that comes in during the first open record period.
I agree. And I will
However,
explain that much more carefully, but let's do it right now. Go ahead. Tell me what you think.
my question is, I would be okay with the dates that Mr. Miller has suggested if that rebuttal period also allowed me to address the information that Landwatch has submitted today. If that rebuttal period does not allow me to submit rebuttal to the information that has been submitted today, the first 7 days is not enough time. Does that make sense?
Yes. Mr. Miller, does staff have any comments on Ms. Lewis's discussion point that the 7-day rebuttal period, when I usually give my spiel at the end and try to explain it, I am usually totally emphatic about the second week is only for rebuttal to what happened in the first week. That's my normal statement. But I'm open to staff's discussion.
Sure. Thank you, Hearings Officer Frank. So as staff understands it, that 7-day rebuttal phase would be specific to new evidence and testimony coming in the first 7 days. So if the applicant would like more time, she is certainly the applicant is willing to propose their own set of phases and timelines that they would like upon your approval.
Okay, no. You and I, you and me anyway, whatever the appropriate pronoun is, we're both in agreement that the second 7 days is typically inferred to be only for a response to what comes in the first 7 days, not prior to that. So I'm going to stick with that based on staff. So Ms. Lewis, would you like an additional day?
So
7
yes, then
days, 2
could we
weeks?
do 26, 3, and 10? So that'll give me 14 days to address the information that came in today in that first open record period.
I don't have any problems with that. All you're doing is pushing my decision about 4 days before Christmas.
Oh, terribly sorry about
I won't celebrate then. So anyway, that's acceptable to me. So here's what we're going to do is the record will remain open at the request of the applicant for 14 days. But more technically, that means that at by 4 p.m. on November 26th, 2024, anyone who wishes to submit any additional testimony or argument may do so. The second 7-day period, which is going to be between the 26th and December 3rd at 4 p.m., is for the sole purpose of responding to evidence submitted during that first 14-day period. And finally, the applicant only shall have an opportunity to submit final argument by 4 p.m. on December 10th. So open record, anyone to the 26th of November, 4 p.m. Anyone wishing to respond to evidence submitted during the 7-day or 14-day open record period may do so by December 3rd at 4 p.m. And finally, only the applicant has the right to final argument. Any questions from staff, applicant, or if Central Oregon Land Watch wishes to come up and ask questions solely about the logistics, because I'm going to make sure that Mr. Miller talks about the submission of information. So any questions on the dates?
Staff doesn't see anyone raising their hand who has a
Cool.
question about.
All right, would you do me a favor, Mr. Miller, and just reiterate how people get information into the record?
Sure. Thank you, Hearings Officer Frank. For the open record period, please keep in mind that all submittals should be addressed to me. For email submittals, use my email, which is nathaniel.miller@deschutes.org. The county does not retrieve information from website links or personal cloud storage devices. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. And then lastly, any electronic submittals must be received by county servers by 4 p.m. So please do not wait until the last minute to submit your evidence and testimony. This concludes the instructions, and I'll turn it back over to Hearings Officer Frank.
Thank you. And I'm going to ask Mr. Miller to do me one more favor. I'm going to ask the audience, whoever is in person or online, any questions about logistics, because I tend to be very, very strict. If I see something comes in at 4:01 on the due date, it is not considered. It is not considered. And so I want to make sure you understand how the information comes in. So any questions?
There are no questions, Hearings Officer Frank.
All righty, I appreciate everyone's testimony tonight. I make the promise that I will review each and every document that comes into the record. And I will consider your testimony tonight, which I find very important. I appreciate everyone's courtesy. Probably more than anything else, I appreciate everyone's courtesy and being respectful in your testimony. At this point in time, the oral testimony in this hearing is closed. The open record period will be in existence going until the 26th, 3rd, and the 10th of December. Thank you all for coming. The hearing is now closed.